the open meetings law actually states what the voters of Colorado initiated in 1972, that it's the policy of this state that public policy shall not be done in secret. It says that, it still says that. But what the legislature did last year is to change the definition of public business as it applies to the legislature. Before, that was something that was determined by the courts, and as it still applies to all other government public bodies in Colorado, public business just means it relates to your policy-making function. But now for the legislature, what that means is that it has to do with some bill that's actually been introduced. The other thing they did is say that any kind of meeting, so an in-person meeting, a meeting by phone, a meeting by email, a meeting by text message or signal where the message evaporates, or it can be set to do that, that is not a meeting anymore under the open meetings law.
What are the fights over open records and transparency? We're going to find out. But first, subscribe and like our channel. Click that little bell icon for notifications and get the Devil's Advocate podcast on your favorite listening app. Jeff Roberts runs the Colorado Freedom of Information Coalition. How long have you been doing that?
12 years, almost. Right. Colorado Freedom of Information
Coalition.
Yes.
What is this? By the way, this group is important and great, and one of the best not-for-profit organizations out there that really keeps government on its toes. What's your mission?
Yeah, thank you. So our mission is mostly to educate journalists and the public about their rights under the open government laws. So that is the public records laws, and we have two of those in Colorado, the open meetings law and court access rules. And we also advocate for greater government transparency.
All right, so the idea of open government, we kind of take it for granted that when politicians are arguing over policy, we should be able to see them. But also, I think a lot of Coloradans don't know that public records are just that, public, that they can see those records. So we have openness, that meetings have to be open to the public, and that when there's conversation over policy, even if that's emails or text messages between elected officials, that's open for public inspection too. Do I have that basically right?
Yeah, unless an exemption in the law applies. And there are some exemptions both for the records of government and the meetings of government, the proceedings of government. So a public body, a school district, a city council, the legislature's a little bit different now because they changed the law last year, but there are occasions when they can close the door on the public. And that's called an executive session. But there are pretty strict rules in the open meetings law for that. And then in the open records law, in CORA, the Colorado Open Records Act, there are exemptions that either allow the government to withhold a record, they have discretion to do that, or they're required to do that. But you have to kind of know the nuance of that.
Let's start off with open meetings.
Yeah.
If my city council is going to make some decisions and discuss policy, I get to watch that. Now, a lot of us are used to that because local TV stations or cable access will have those meetings live. And that's really pretty cool because when you and I were kids...
Or they're on YouTube now.
Yeah, we never saw them. And we can look and find their prep material, their agenda, and their study material. So we can actually follow what they're talking about if we so care.
Usually.
If they go into executive session, well, we want to fire our city manager. Mm-hmm. They go into we can't see that. Is that correct?
Right. So there are some rules about that, though. If they go into executive session, they have to, those are really for deliberations on certain topics. They're not for making decisions. So they can't come out of the executive session and say, we have decided in the executive session to fire the city manager. And there's no discussion in public about that at all. So one example of that, fairly recent, very important, when there was a school shooting a student actually shot two administrators at East High School a couple of years ago, the Denver School Board went into executive session the next day for 5 hours. And they came out of that executive session with a brand new policy about whether armed officers should be back in the high schools. They hadn't been there, and they came out and they changed the policy. Well, the open meetings law specifically says you shall not be making decisions in executive session. So a bunch of news organizations got together and filed a lawsuit about that, and eventually got the recording released. The recording of an executive session is typically not public because it's an executive session.
But tell me if I got this right. When there is an executive session, and we're talking about all levels of government.
Yeah.
Colorado has some 5,000 different governments
Yeah.
and special districts. If they have a special session, they have to have at least an audio recording of that, don't they?
Yes, they have to have an audio recording of the executive session, except for the portions where they're getting legal advice from their attorney. So I have heard stories about some governments going into executive session saying this is going to just be all legal advice, yet they talk about other things that that may not be authorized. But it's very hard to know about these things and get those recordings.
That just seems like it's ripe for abuse, which is, we've got an attorney-client privilege, we, the city council, and our attorney, and now we're going to talk about legal stuff. Click, and we have no sense of what they're talking about or anything they do. Now, I understand why you want to go into an executive session. You're thinking of using eminent domain, and you're going to talk about, well, what should our bargaining position be? What should we offer this guy for the land? All right, great. Because if that guy could just listen in and say, our top offer has to be $1 million, not a penny more, he knows to wait for $1 million. So I get that, but there's got to be a way to make sure that when they go into an executive session, it's for those reasons and not for the reasons of discussing policy outside of the voters' eyes.
I mean, the law is set up to be kind of guardrails, not just for the public, but for the people participating in the executive session. And their attorney really should be keeping them on the topic, assuming they have an attorney in the room with them. But they do, you do hear examples, I hear examples of governments going off topic, and it is difficult to watch over that. Really, it has to be kind of blatant. The school board coming out of the executive session with a piece of paper with a new policy that they wrote in the executive session. That's kind of an indication that maybe they did something in the executive session that perhaps they weren't supposed to be doing, which is making a decision. So the public needs if somebody's going to challenge that, there needs to be sort of a clue. And then what they need to do then is ask, if they go to court, a judge needs something to review, and that's where that recording comes into play.
Step back, give me a 30,000-foot view on this. Why is the idea of an open meeting or open records that can be inspected, why is that important? What do we care? We've elected these people. If we don't like what they're doing, we can always vote them out of office next time around. Why is this a core function of government to let the process be seen? Yeah,
so we're taping this episode during Sunshine Week. So Sunshine Week is a national celebration of these open government laws. And we have it in mid-March because that's when James Madison's birthday is. And James Madison was the founding father who articulated most about why the government they were created needed to have some element of transparency, some openness. And what he said and what they said back then is, for it to work properly, the people need to know something about what government is doing so they know how to vote in elections, they know how to hold government accountable. And that's what it's really all about. If you don't have access to the proceedings, to the records, how are you ever going to scrutinize that?
Which means that people need to know when a meeting is going to happen.
Yeah.
I've been an elected official. When we would have a meeting, we had to post it on the front door of the building. Now there are other ways to put it out there so that people can see it electronically if they're looking for it. If there's going to be a meeting at the state capitol, it's going to say this committee is going to consider these 3 bills in this meeting. And so people go, I want to listen in, I want to watch, I want to be there in person, I want to talk to them. I get that just like the First Amendment says newspapers and freedom of the press and our freedom of expression is an important check and balance to the whole system, these open meetings are also an absolute necessary to have the check and balance. Otherwise, you've just got guys in smoky back rooms making every decision, and then they'll run up in front of the public and go, I vote yes on this amendment, and without knowing why or how. That's why what happened last session with Senate Bill 157 was one of the most blatant violations of open meetings I've ever seen. Explain this to me, because as I see it, the state legislature said, yeah, open meetings are great, but not for us. And they voted to exempt themselves from a large part of this law that we hold so sacred. And how long have we had the open meetings law?
53 years, 1972.
And the people of Colorado voted directly on this law because we wanted to do this. It reminds me of so many other things like Tabor that's voted on by the people and they find ways around it. I had no idea that the legislature could exempt themselves from open meetings. Tell me the story.
And they can do that because it's in statute. It's not in the Constitution of Colorado. So you look at the legislature and you can, I mean, in a lot of ways, the proceedings are more open than they used to be because you can go on YouTube and see the floor debates. You can listen to the audio of the committee hearings. Now,
you can't see the.
You can't see them.
We're one of 2 states where you cannot see the committee hearings.
I discovered that last September when I was writing a blog about the fact that we don't video stream the committee meetings in the legislature. And the National Conference of State Legislatures actually has a webpage devoted to this topic, and it's only Colorado and Maine that have audio only. So that's
quick aside, so folks get this one. Every single committee room in that Capitol is set up for Zoom meetings. There are cameras, large monitors. They are set to go ahead and just broadcast that and stream it live. All they have to do is flip it from private to public, and they won't do it.
Well, we may be making some strides along those lines. I think
we might have embarrassed them enough.
I think it will happen eventually. But so you can watch certain proceedings, you can listen to other proceedings, you could go there in person and sit in on those things. But what you may not be able to do is find out what's happening behind the scenes. And sometimes that's important because you don't necessarily know when you're watching something in the committee if it's been predetermined. So
let me, just for people who don't know, it is almost always predetermined. You can go and testify, and it's important that you learn, and you surely should try testifying sometime. It's an experience. But I would say 98% of the time, the goose is cooked before the gavel opens up any committee hearing.
So, the open meetings law actually states what the voters of Colorado adopted, initiated in 1972, that it's the policy of this state that public policy shall not be done in secret. It says that, it still says that. But what the legislature did last year is to change the definition of public business as it applies to the legislature. Before, that was something that was determined by the courts, and as it still applies to all other government public bodies in Colorado, public business just means it relates to your policy-making function. But now for the legislature, what that means is that it has to do with some bill that's actually been introduced. The other thing they did is say that any kind of meeting, so an in-person meeting, a meeting by phone, a meeting by email, a meeting by text message or signal where the message evaporates, or it can be set to do that. That is not a meeting anymore under the open meetings law. So that's not how it is for local government still, but for the legislature, it is no longer a meeting. And what that
Let me
yeah.
shout out some outrage here. There are 5,000 governments in Colorado that must keep records of their communications, that must announce when they're going to have a meeting so that people, including reporters, can go, oh, I better watch that.
Yeah.
Only one out of these 5,000 governments have said, we don't need to do that. So we can now have a meeting and then tell you after the fact that we had a meeting so that reporters don't have the opportunity to watch what goes on. They have now the ability to message each other in ways that the message disappears. Now, and we also have, and this is a different subject, we have these retention rules for communications among lawmakers. Now, every time I send a naughty email to a woman, it has been saved ever since the beginning of Google's existence. Yeah. It is there for 30 years. But no, these guys have a 90-day retention policy on their emails for a 120-day session. So you cannot go back and find out what they've done, which tells me they want to hide some stuff. And I just find this to be the most insulting thing I've seen in decades down there.
Well, you also would have to know what to file a core request for. So how do you pinpoint that when you don't know if they've actually communicated that way? But if you do find out, if a reporter is interested in a particular topic and they feel like perhaps there was something happening behind the scenes that would be of public interest to find out, you could make a core request for that. But as you say, the records may no longer exist, or they may fit the definition of work product in the law, which means that they're not a public record. So it can be very difficult to get at that type of thing. Now, the legislature did this because they said that they didn't want to be violating the law by just having conversations with one another about policy. But they've lived with the open meetings law now for 53 years, and they were been able to do it. I think what happened here is they got sued a couple times. They got sued by two members of the House over these disappearing messages and not properly noticing caucus meetings, which are public bodies, the de facto public bodies. The Colorado Supreme Court said so in 1983. And then there was a system called quadratic voting that the legislature was using, which was a kind of an anonymous balloting system to rank bills that affect the state budget. And they could do this at home, and it was a way to prioritize these bills, and the public did not get to see how
Let me take a shot at this and see if I can put this in English. So they figured out a way to basically vote on what they're going to be voting on, and to do it anonymously, that they could do it behind closed doors, and figured out a way where we all get to express what our priorities are. And now we figured out that our priorities are X, Y, and Z. Well, then we just bring it up for a floor vote. So the meat of what is governing, the back and forth, the discussion, the way they vote, was done behind closed doors. And the Supreme Court of Colorado, I believe it was the Supreme Court, said, no, that's got to be open.
It was a district court.
District court.
Yeah.
And to say that you could have these meetings, I love this thing. They're claiming they had to make this change because what if I'm talking with somebody in the stairwell? Well, you've been talking to people in the stairwell for 150 years of Colorado's existence. So that's not what we're talking about here. We're talking about when you have a meeting and policy is going to be discussed and it's going to be a substantive meeting, you need to put it out there. As soon as they changed the law, the Democrats used this newfound power to be secretive, to discuss what they were going to do and make the deals on property tax issues on the special session during the summer. So it took them a few weeks to start abusing this new power. I remember testifying in front of them, and one of the Democrats said, hey, if you want to know what happens in those Democratic caucuses, and for those who don't know, Democrats have a caucus, Republicans do, they meet and they discuss how best to work as a team and what the priorities are. But those are open to the public, except now for the Democrats, we only find out after the fact. And I love the response I got, which was, hey, if you want to read the minutes of what happened, you can watch. You used
are great.
You're used to be a reporter. If you were like, hey, you want to recover this? We'll show you the minutes of what supposedly happened. Is that actually seeing what happened?
No. And there's nothing in the open meetings law. I mean, the open meetings law says they must take minutes of a lot of their meetings, but there's nothing that says how good they must be. So
or who said what to whom?
Exactly. And that's why.
Or what the deal was. I will pull this bill if you bring that bill, but you're going to do this bill. All right, we all have an agreement. Instead.
So I actually thought that when Senate Bill 157 passed, it would be kind of difficult to keep track of how it actually affected how the legislature worked or the transparency of the legislature, because it allowed more or took away those guardrails for saying you're not supposed to be communicating by signal behind the scenes in large groups and things like that. And how would you know? So how would you know about that unless you could figure out what to Quora for, if those messages existed? So we still don't know a lot of that, but we do know that they excluded reporters from caucus meetings before the special session on property taxes. And that was pretty blatant. And that, I was surprised. I was kind of startled to see that.
Here is how arrogant they have been. The new law that closed these open meetings said, well, once a year, we, the executive legislative committee, leadership from both parties, need to have a committee hearing to talk about how it's going and take public testimony. So when do they decide to have last year's meeting and take public testimony? On quite literally the last day the building was open for the entire year, when everyone else was busy working on family, Christmas, New Year's. They tried to sneak this meeting in there. And the Speaker of the House, Julie McCluskey, has the balls to say, oh, we believe in transparency. We're working to make our system as transparent as possible, when it was her bill that took away these open meetings. I don't know about you. I find this to be just a complete insult and slap in the face to every Coloradan. Tell me I'm wrong.
Well, people did show up to that meeting, which was good. We got a lot of us got people mobilized to come and talk and say how they felt about that bill and the exclusion of people from the caucus meetings. So at least they heard about that, and at least since then, I think there's been more dialogue than there was about what they're actually, their issues were about wanting to talk in, amongst themselves in private on a bill, something like that, versus the public's right to know. There's been more discussions about that.
We're not going to change that until we, the people, step outside of the legislative process and pass something. I want to get to what they're doing this year. Senate Bill 77 takes that insult and adds on to it. What does 77 do this year?
So Senate Bill 77...
It's still in the process, so it could be different when people hear what we're talking about.
Right, it could be, potentially. Senate Bill 77 is the 2025 version of a bill that was first introduced in 2024, affecting CORA, the Colorado Open Records Act, not so much the Open Meetings Law. And what this does, it's supposed to be about giving government records custodians are the people at government entities who take care of the records and are supposed to provide them to the public, to give them a little bit more of a break, because there's a perception that they're overburdened by more records requests by people bombarding them, supposedly. So what it does is it gives them extra time to respond to the records request. Right now in Cora, the presumption is 3 working days to respond to requests, but if extenuating circumstances apply, and that's spelled out in the law, it could be another 7 days, 7 working days, for a total of 10. The problem with that is actually a couple of problems with that, is that those response times are frequently fudged, and there's not much the requester can do about that. In fact, sometimes there's nothing the requester can do about that. You probably can't even sue over something like that. There was a lawsuit filed against the judicial branch last year. This is not Cora, but this is the judicial branch's records rules, which are worded in some ways very similarly. The lawsuit was over a delay of response for months. The person eventually got their records, but because it took months for them to get it, but because they actually got the records in the end, the Court of Appeals said, you didn't really have standing to sue over this because you could only sue over a denial of records. So you got your records, it wasn't a denial. If there was a lawsuit over Cora this way, my guess is that we'd have a similar outcome. So the person filing the request, if they eventually get the records, even if it takes months, they didn't really have standing to sue over that. The thing that is also happening here is that the fees can be very, very high. So until we do something about the fees, I think creating more obstacles in the law, it just makes it harder to find out what your government is doing.
So what people need to know is they have a right to these records. When they request the records, they have 3 days to hear back. They can say, wait a second, we need another 7 days for extenuating circumstances. Then you're supposed to get your damn records. But also they put up a hurdle of money. Oh, yes. Well, that's going to cost $50 an hour for us to go through our email to do this. And it jacks up the price so much that it is prohibitive to see what your own government is doing. So we've got a situation where different governments do it in different ways. We found that at Independence Institute. We did a survey of some different colleges. We found that some colleges gave up this information. Oh, here, I'll put it on a DVD for you, send it out, no cost. Others said, no, we're going to charge you thousands upon thousands of dollars. Others said, we're not giving it to you at all. You have to come down and look at it yourself. And we're going to charge you $1 a page or something ridiculous like that. So all these obstacles are happening. Senate Bill 77 makes those obstacles more expensive, more burdensome, and more time-consuming. The idea is to say, well, the guy who does the records, she's on maternity leave. She'll be back in a half a year. Maybe we'll get to it then. This is our government working on our work. We are the government, but yet we have no right to see what is being done in our name.
So the fees just went way up last July 1st. The maximum they can charge is not $50, but $41.37 an hour after the first hour, which must be provided at no charge. And so it went up 23% last July 1st. It was $33.58 an hour because there was an inflationary factor built into Cora in 2014. And so before 2014, governments were charging all sorts of rates, $20 an hour, $80 an hour, $130 an hour. So the legislature standardized that, but what they didn't standardize was the number of hours that they can multiply that rate by. So $41.37 an hour times 5, 10, 20, 30 hours, depending on what you've requested and how long they say it will take to produce the records. And that often can mean not just pulling the records, but reviewing them before they go out, because they want to make sure that there's nothing that in there that either they can't release or they may have discretion not to release. That's what makes records requests very expensive. So recently, very recently, a person made a request of a library district in Colorado Springs asking for information about leases that they have for the buildings, the library buildings. And it was a broader request than I would have advised them to make. It was asking for emails and text messages and other documents. And this person got a quote of $25 million.
You're joking.
I am not joking.
$25 million.
I'm not joking. I'm probably going to be writing about this for my blog. And I actually have I've talked to the requester, but I haven't talked to the records custodian yet. If they will talk to me, I'd like to get their perspective on how they made that calculation. That is the most extreme one I've ever seen in my 12 years doing this job. You could maybe build a library
easily
for that and name it after the records requester. I don't know.
Let's wrap it up with this. You've been doing this for a long time. You were a reporter. You've seen this. Compared to the last several decades, what is the state of transparency in Colorado?
Mm-hmm. There are some areas that we've actually improved upon. And I would say when you're talking about some areas of police accountability and transparency, Colorado's definitely made strides in that area with body cam footage being more available, although we have some cases in the courts about that, with police internal affairs records being more available. But as far as just public records in general, the CORA is the law that most people use. It's
Colorado Open Records Act.
It's the one that covers everything except police records. I think we've taken a step back. And the reason I say that is because there are more exemptions in the law. There's exemptions added every year. If Senate Bill 77 ends up passing, we will have longer response times for the records custodians, which wouldn't be so bad if they had done something about the fees. And it's the fees, it's what they haven't addressed, I think, when you mix all that together, that creates more burdens for the records requester. And there's always going to be a balance between the people's right to know and what the government needs to do to produce those records. People have various thoughts and opinions about how available public records should be. Should it be a priority of government to be providing records? Should they devote more resources to doing that? There's always going to be a tension there. But I think it's kind of out of whack right now. And the governments would say it's out of whack because they're burdened by records requests. But I think it's out of whack because of the cost, the fees that people have to pay, and the fact that the governments have pretty much most of the say about when people can get those records, and sometimes they don't apply the exemptions correctly.
Burden. To hear them complain about the burden of open government,
Mm-hmm.
I find arrogant. No. Excuse me. Your job is to be open. These people you are being open for are not burdensome. These are the taxpayers for whom pay your wages. These are the citizens for whom you serve. And for them to talk about how, this is being weaponized against us. No. People want to know what's going on in their governments. This is as healthy as it can be. And I see between closing down open meetings and making it harder to see inside, people wonder, so why is it that there's so little faith in government these days? Why is it that somebody like Donald Trump can get the popular vote? Because people know that those people in government are doing things they want to keep private. And this only feeds that, not the opposite. And sooner or later, there will be a reaction to it, and they're not going to like it down there. And our Freedom of Information Coalition that you run has been a stalwart of that You and I are part of a transparency coalition trying to make an amendment to the Colorado Constitution on it. And I think they're going to see Colorado Freedom of Information Coalition, people need to know about. They've got great resources. You do a great blog. People want to get involved. Where do they go?
ColoradoFOIC.org is our website. On that website, you're going to find a lot of resources. So as you mentioned, there's a blog there. Me being a former reporter and editor, I cover open government like a beat. So lots of articles about court decisions, what's happening in the legislature, some commentaries about open government in general. But you're also going to find a very, very comprehensive guide to our sunshine laws. So the open records laws, the open meetings law, court access rules, lots of great information on there. And then we run a hotline. So when people have questions about how to use these laws, or they get a denial that they're wondering about, they can contact us. And so email, phone call, whatever, and we try to help anybody who calls.
It's incredible. Jeff, thank you. If you're not following the Colorado Freedom of Information Coalition, just do it. It's Colorado FIOC.
Colorado FOIC, Freedom of Information.
Freedom of Information.
.org.
Just do it. Get on their mailing list. You will not regret it. Jeff, thanks.
Thank you.
If you enjoyed that conversation, by all means, click one of these other great programs. We have the best conversations with the most fascinating Coloradans. And subscribe to our channel. Just click down below and hit that little bell button too. You don't want to miss a single show.